and hopefully we'll all be able to see each other in person sometime soon. But I'm happy to do this presentation on bankruptcy, everything you need to know and are afraid to ask. So bankruptcy. Historical bankruptcy numbers. The last decade saw a steady decline in bankruptcies, with the largest numbers coming in 2010 during the Great Recession and foreclosure crisis. The majority of those bankruptcies were personal bankruptcies, with many designed simply to delay the foreclosure process occurring in state courts throughout the country, including Florida. Bankruptcies have since steadied and declined in number from 2010 through the present, but that may be about to change. So these are the March total bankruptcy filings from 2010 to 2020, and you can see the historical decline that's occurred. So bankruptcy in 2020 and beyond. So in this rapidly changing economic dynamic, it can be hard to predict how expansive the COVID-19 crisis will be, how long it will last, and what impact it will have on personal and business finances. That said, most experts are preparing for an expected spike of bankruptcy filings in the second half of 2020 and beyond. So MarketWatch just this weekend suggested that there's going to be a wave of bankruptcies, surging taxes, and Americans harboring lasting scars from coronavirus lockdowns. The head of the world's largest asset management warned of a grim outlook. Fink, speaking privately with clients of a wealth advisory firm, outlined an unattractive future in which the economy continues to weaken, bankruptcies soar, and American consumers remain scarred from the coronavirus and the death and the jobless claims. So let me give you an overview of bankruptcy. The Constitution gives Congress the authority to enact uniform bankruptcy laws for the entire country. The current law is the Bankruptcy Reform Act of 1978, which is codified in Title 11 of the U.S. Code, the Bankruptcy Code. Major changes were enacted in 2005 when Congress enacted the Bankruptcy Abuse Protection and Consumer Protection Act, BAPCPA. It's kind of a misnomer where it says Consumer Protection Act, because a lot of the regulations were designed to make it more difficult for individuals to file for bankruptcy. So a lot of us in the consumer world didn't necessarily think that it protected consumers. Recent changes include the Small Business Reorganization Act of 2019, which I'll talk about, and then technical fixes. Congress included changes to numerical requirements and credit and debt limits within the CARES Act. So how is the Bankruptcy Code formulated? Chapters 1, 3, and 5 are applicable to all bankruptcy cases. Chapter 1 includes definitions, rules about who can file bankruptcy, generally describes the power of the bankruptcy courts. Chapter 3 governs case administration, includes rules regarding filing cases, employment of professionals, including attorneys, establishing the automatic stay, which I'll talk about, selling, using, or leasing bankruptcy assets, obtaining financing, rules on executory contracts and unexpired leases, and dismissing and closing cases. Chapter 5 covers matters related to the rights of debtors and creditors, including claims and their priorities, exemptions, what constitutes property of the estate, and avoidance powers. The types of bankruptcy cases are set forth in chapters 7, 9, 11, 12, 13, and 15. So chapter 7 is personal liquidation. Chapter 9 is municipality bankruptcy. Municipalities can file, not states. Chapter 11, business reorganization. Chapter 12, family farmer bankruptcy. Chapter 13, individual debt adjustment, which is personal reorganization. And Chapter 15, which is cross-border insolvency, which is not going to be discussed today during my presentation. So the procedural rules. Procedural rules are governed by the Federal Rules of Bankruptcy Procedure, the FRBP, the bankruptcy rules, and the local rules of each bankruptcy court. Florida has specific rules for admission and practice beyond those of Florida state courts or other bankruptcy courts. So they require you to have a specific and verified knowledge of the bankruptcy code and rules and require specific bankruptcy CLE credits during each 3-year continuing legal education credit cycle that lawyers have in Florida. The bankruptcy process. You're going to meet with your attorney in advance. Consultation with an attorney and a review of the bankruptcy process is essential. Specifically, the attorney will often assist with pre-bankruptcy planning, namely the process of converting the debtor's property from non-exempt assets to exempt assets so as to take advantage of state law exemptions, protecting property that would otherwise be surrendered to creditors. And then individual debtors must participate in pre- and post-bankruptcy credit counseling and financial management classes. You can do those online or over the phone. So the bankruptcy petition. Bankruptcy petitions are filed electronically with the court and assigned a case number, and then the clerk's office will assign a judge and a panel trustee in the case of Chapter 713 and small business 11s. The automatic stay. The automatic stay is one of the most important and sacrosanct things that exist in a bankruptcy case. Upon filing of any bankruptcy by any debtor in any chapter, the bankruptcy petition invokes what's called the automatic stay, which is an injunction that stops any and all lawsuits, foreclosures, garnishments, and collection activities against the debtor, and in Chapter 13 cases, sometimes against the co-debtor. Automatic stay can be lifted, but we'll talk about that later. Initial meetings of creditors, 341 meetings. All debtors must appear at an initial meeting of creditors required by Section 341 of the Bankruptcy Code and colloquially referred to, apologize for the spelling error, as the 341 meeting, at which time the debtor is questioned under oath by the trustee and by any interested creditors who may appear. Confirmation. After notice and hearing, a bankruptcy judge will approve a plan of reorganization or liquidation in Chapter 11 or a payment plan under Chapter 12 or 13. And then reaffirmation agreements. And that's an agreement in a Chapter 7 case by the debtor to continue paying a dischargeable debt like a mortgage or an auto loan so that they can keep the house or the car that would otherwise be subject to foreclosure or repossession. So I'm going to go through the chapters and explain some differences between each case. So Chapter 7, entitled Liquidation, contemplates an orderly, court-supervised procedure by which the standing Chapter 7 trustee takes over the non-exempt assets of the debtor's estate, reduces them to cash, and makes pro-rata distributions to unsecured creditors, subject to the debtor's right to retain exempt property and the rights of secured creditors to their specific property that they have a lien on, like houses or autos. In a Chapter 7 case, if the debtor is an individual, he or she receives a discharge that releases them from personal liability for certain non-dischargeable debts. Violation of that discharge order by a creditor subjects them to sanctions, legal fees, and penalties. Chapter 13. Chapter 13, entitled Adjustment of Debts in an Individual with Regular Income, is designed for just that, an individual debtor who has a regular source of income. That could be employment, alimony and child support, or Social Security income. Chapter 13 is often preferable to Chapter 7 because it enables the debtor to keep a valuable asset such as a house, and because it allows the debtor to propose a plan to repay creditors over time, usually 3 to 5 years. Chapter 13 is also used by consumer debtors who do not qualify for Chapter 7 relief under the means test, which was an effect of the BAPCPA reform that I discussed earlier. You have to have certain debt and credit amounts, and you have to have no ability to repay those debts in order to qualify for Chapter 7. They call it a means test, and sometimes consumer attorneys refer to it as a mean test, meaning that it's mean to debtors who would otherwise be eligible for Chapter 13 absent the BAPCPA reforms. So BAPCPA's effect on Chapter 7 and 13. The BAPCPA was enacted in 2005, represented a significant reformation of the Bankruptcy Code as enacted in 1978. Under BAPCPA, filing for Chapter 7 personal bankruptcy became more difficult as more stringent guidelines and eligibility requirements were defined. Specifically, the debtor is required to satisfy a means test. The goal was to prevent the bankruptcy process from being abused and to encourage more Chapter 13 filings instead of the more forgiving Chapter 7. Whether Chapter 13 was being abused, whether Chapter 7 was being abused and whether the government needed to encourage more Chapter 13 filings is a political question. So the means test. Section 707B2 of the Bankruptcy Code applies a means test to determine whether a debtor's Chapter 7 filing is presumed to be an abuse of the Bankruptcy Code requiring dismissal or conversion to Chapter 13. Abuse is presumed if the aggregate income over 5 years is more than $10,950 a month, or 25% of the debtor's non-priority unsecured debt, as long as that amount is at least $6,575. And the debtor can rebut a presumption by showing special circumstances. The fallout from COVID-19 will cause otherwise healthy businesses to fail, leaving small business owners with personal liability that in other circumstances would have been paid by the business. Having more business debt than consumer debt will make those business owners eligible for Chapter 7 without them being subject to the means test. So what that means is that anticipating business failures, if those businesses fail and the business owners have personal guarantees and liabilities associated with the business that they have responsibility for absent the corporate veil, then they will be eligible for Chapter 7 because that debt is business debt, not consumer debt, and the means test will not apply. It's definitely the law of unintended consequences. So reasons to file Chapter 13, ineligible for Chapter 7 due to the means test. It's a homeowner seeking to repay mortgage arrears on a house or loan arrears on a car while making regular payments in the future. Prevent wage garnishment while paying off a tax bill, child support obligations, or other non-dischargeable debt, and keep otherwise non-exempt property. So there are definitely reasons to file a Chapter 13 over a Chapter 7 if you're an individual. Chapter 13 debt limits. So as of April 2019, the debt limits were secured debt, no greater than $1,257,850. Unsecured debt, no greater than $419,275. So those debt limits change every 3 years, and the figures are accurate through April 2022. And so if you have a house that's worth $1 million, you're going to fall under and you have no other secured debt or secured debt of less than an additional $257,000 and change, you're going to be eligible for Chapter 13. If you have a house that has secured debt of over $1.3 million or close to $1.3 million, and you have other secured debt that might put you over that 1.2 and change limit, then you're going to be ineligible for a Chapter 13, and you would be filing a personal Chapter 11 if necessary. So the CARES Act in Chapter 13 made some definite changes that are beneficial to those in or looking to Chapter 13. The first is that under Section 1113 of the CARES Act, the payments that people received from the IRS that were equal to $1,200 per family plus the additional monies for dependent children are not included as part of monthly income or disposable income when filing for bankruptcy, and that change is going to remain in effect until March of next year. So if somebody files for bankruptcy over the summer or the winter or next, early spring, that rule is going to remain in effect. Also provides temporary changes to Chapter 7 and 13. As I said, for purposes of calculating a debtor's income to determine eligibility, the COVID-19 payments are excluded from the means test, and they're not included as disposable income. Lastly, Chapter 13 debtors who have already confirmed a Chapter 13 plan would not normally be allowed to modify it. They're allowed to additionally modify it and extend their payments for 7 years after their initial payment was due. And again, these are going to be changes that are effective for 1 year from the effective date of the CARES Act. So if you were a debtor in a bankruptcy case and you proposed a plan based on what your income was before coronavirus and before the pandemic and lockdown, then you're going to be able to amend your plan and extend the payments out over an additional period of time than you otherwise would have been under normal circumstances. Chapters 9, 12, and 15 govern very specific types of bankruptcy, municipalities, family farmers, and cross-border insolvencies. We're not going to talk about those today. Chapter 11. So Chapter 11 is entitled Reorganization. It's ordinarily used by businesses to continue operating and repay creditors through a plan. Under a Chapter 11 plan, the debtor can reduce its debts by repaying a portion of its obligation and discharging others. The debtor can also terminate contracts and leases that it doesn't need or that are burdensome. It can use that termination power to renegotiate those contracts and leases. It can recover assets, and it can rescale its operations in order to return to profitability. And it's a period of consolidation where the debtor emerges with a reduced debt load and a reorganized business. As indicated, if you're an individual over the Chapter 13 debt limits, then you can file a Chapter 11 personal reorganization. So pre-bankruptcy planning for a Chapter 11 business. For a distressed business or individuals, bankruptcy is generally an option of last resort, but it can be a valuable tool for debtors to level the playing field with creditors. Comes with costs and risks. The difficulty in this environment of uncertainty is that no business can make realistic projections of their future earnings. No industry is unaffected, and nearly every industry is suffering. The smart strategy is to start planning ahead. Distressed business leaders should work with their experienced bankruptcy professionals, evaluate options, and prepare for a moment where we have a better view of our economic future. So special debtor powers, the automatic stay. Filing for bankruptcy imposes an automatic stay on any and all litigation and collection efforts against the debtor, gives the debtor a power to reject leases and contracts, thereby reducing obligations on a going forward basis and giving debtors a stronger hand in negotiating. A caveat to this, if you're a business owner who signed a personal guarantee, then you're still going to be obligated under the personal guarantee, notwithstanding any rejection of the lease or contract. And then DIP financing. Debtors can obtain special financing from lenders who can obtain priority over other creditors. So a existing or a new lender can come in and supersede any of the loans that were given pre-bankruptcy and take priority in repayment in exchange for those debtor in possession loans. So negotiating with vendors, creditors, landlords, and or lenders pre-bankruptcy and during bankruptcy. You need to review the applicable contract, lease, and or loan documents. You need to prepare a list of important concessions that you need and want. You need to ask for help and communicate. You need to get a new deal in writing. In bankruptcy, it's subject to court approval. And then you need to take short-term victories and negotiate again later. There's nothing wrong with taking the deal now, kicking the can 30, 60, 90 days, and then seeing where things are. Pre-bankruptcy financing. Contact your existing lender for additional capital and or renegotiation or refinance of existing loans. Avoid personal guarantees. Explore other lending sources. Consider seeking equity investors. And again, take short-term victories and negotiate again later. Chapter 11 funding options. So as I said, debtor in possession financing is a special form of financing that's provided for companies in financial distress in a Chapter 11 case. It's subject to court approval and usually involves the lender getting special priority and treatment over pre-petition creditors, including pre-petition secured creditors. Small Business Reorganization Act of 2019. So the SBRA took effect on February 19th, 2020. It endeavored to strike a balance between Chapter 7 and Chapter 11 bankruptcies for small business debtors. It was enacted to attempt to reduce the cost and expense for small businesses to reorganize under Chapter 11, specifically by lowering the costs and streamlining the plan confirmation process to give small businesses a better ability to survive in bankruptcy and retain control of their operations. It was enacted February of 2020. It barely got a chance to go into effect before coronavirus took over the country and shut everything down. So it really hasn't been seen in action yet. Under the SBRA, a debtor must file a Chapter 11 plan within 90 days, but they don't have to file what's called a disclosure statement, which is an explanation of their history and the manner of their payments and how all the creditors are being treated. The plan and disclosure statement are going to be combined into one document. To qualify as a debtor under the SBRA, the debts of the company must not exceed $2,725,625. These debts have been temporarily modified and raised by the CARES Act. Specifically, the $2.7 million limit was raised to $7.5 million, and it applies for 1 year from the enactment of the CARES Act. And then it'll go back down to 2.7 or be subject to additional modification by Congress. So we talked about what a debtor can do in bankruptcy. I want to talk for a minute about what creditors can do in bankruptcy. Creditors have a significant set of remedies available to them, including but not limited to the right to initiate an involuntary bankruptcy case on a corporate debtor who might not be ready or willing to file their own petition. This is an aggressive step by one or more creditors who might be owed a significant amount of money and might feel that their monies are at risk because they're unsecured. Relief from the automatic stay. A creditor may request relief from the automatic stay in order to allow them to continue state court litigation against the debtor, such as in a foreclosure case or eviction. Adversary proceedings. In a Chapter 7 case, the trustee, or in a Chapter 11 with the debtor acting as trustee, they may commence an adversary proceeding to recover money or property. A proof of claim, creditors will file a written statement to see if their claim will be paid. Service Members Civil Relief Act. This provides protection against members of the U.S. military against the entry of default judgments while they're on military duty, and allows the court to stay proceedings against them. Concluding thoughts. COVID-19 is going to have significant sweeping impact on our lives and our businesses. Businesses will need to adjust to these health and challenges and societal concerns. Social distancing, telecommuting, and virtual meetings will be a part of our vocabulary and lifestyle for a significant time. We may have a second wave in 2020, and consulting with professionals can save time and money going forward. So this was designed to be a short primer into all types of bankruptcies, and I am happy to answer any questions that people have. Let me just go to the chat and read it. Okay, so the chat was about people coming in late and leaving early. And there'll be a copy of the presentation, and I apologize if I sped through it, but wanted to make sure we got to everything and left time for questions. And I'm happy to answer questions that people have. So is there silence because nobody has questions, or silences because everybody's confused? You know, I've been practicing bankruptcy for 25 years. I started my law career as a law clerk to a bankruptcy judge, and I've represented debtors, creditors, and trustees. And I'm definitely anticipating a significant rise in bankruptcies, but also think that businesses need to be aware of who owes them money. I was on a Zoom call yesterday with some professionals, and one of them has a client who she does some legal headhunting for, and the law firm owes her commission payments that were supposed to start in May and go through December, and they sent her an email the other day asking if they could delay their payments until December, and the consensus on our call was that she needs to get ahead of that and start collecting some of that money sooner rather than later, as it's definitely possible that the law firm itself is having financial difficulty. So, Bianca, just ask anything if you have a question, and yeah, I can review the slides and go through it, and let me go back in again. It's not as easy for me to share the screen and view the questions. So
Ron, if you want to go back through your slides, I'll just kind of keep an eye at what the questions are, and as I see them written, I can read them out to you if you'd like.
That'd be great.
Okay, perfect.
So can everybody see my screen with the PowerPoint?
Not yet.
Give me 1 second, because that's what I'm trying to figure out is how to share the screen again. I'm trying to get to where I can do the, give me 1 second, I apologize. All right, so now I have it as slideshow. Can everybody see that?
Yep, it's on the screen now.
Okay, so, you know, this was my review of the historical numbers and the statistics. I'm not sure there are going to be a lot of questions about that. And then the predictions for 2020. And if I could just, you know, stop for a minute and talk about the predictions. I mean, you know, you watch the news, businesses are going out of business left and right. Some of them aren't even going through the bankruptcy process or going to go through a liquidation process. Sweet Tomatoes, the restaurant, announced they were going out of business the other day. That their announcement was based on the fact that they're a buffet restaurant and they do not see a future for buffet restaurants in the short term or even the, you know, intermediate term, and that they couldn't convert to a different type of service, table service, and didn't want to. I don't know what that's going to mean for all the Asian buffets that we see down in South Florida or Golden Corral or the like. And I wouldn't even begin to predict how that's going to affect resorts like Disney or Universal that have significant buffet style meals, or cruise ships who, you know, sell the buffet as one of their, you know, hallmarks. And how that's going to affect business operations is going to be a very interesting dynamic as we move forward.
Bianca, all of this will be uploaded to the Chamber's website, Facebook, and YouTube, and we can also go ahead and make sure that we send you a copy of this. That way you have access to the URLs that you'd like to click on.
I'm happy to answer any specific questions that people have. And, you know, you can go to my website and schedule a 15-minute or 30-minute, you know, consultation or question session with me. I'm happy to advise individuals and businesses about what's going on. And you can either go to my main site at canninglawoffice.com, or you can go to coviddebtproblems.com and fill out the form on the new website. Were there any specific questions in the chat? I can't see.
None that are pertaining to the slides.
Chapter 7 is liquidation. Chapter 13 is individual reorganization. Chapter 11 is business reorganization. If you have any questions about those chapters, or if you're a creditor who might have issues with a potential, you know, debtor or existing debtor, I'm happy to answer them.
Bianca is asking,
so,
how long does the process typically
take? Now I can see it.
Okay.
That really depends on whether it's a 7, 13, or 11. It's also complicated by the fact that, you know, everything's being done virtually right now, including 341 meetings. A Chapter 7 shouldn't take more than, you know, a couple of months from start to finish if there are no issues with, you know, if there are no objecting creditors and there are no questions that the trustee has that might lead the trustee to object to the discharge, then it should take, you know, a relatively quick amount of time. A Chapter 13 is going to be different because while start to finish filing to confirmation, again, is going to be, you know, a couple of months. The Chapter 13 plan can last 3 to 5 years, and now there's a COVID extension to allow the plan to last more than up to 7 years. So the Chapter 13 debtor will be making payments over that 3 to 7 year period, but there won't be any court activity. The case will effectively be closed except for the trustee collecting and dispersing payments. So that's where that one will last. And a Chapter 11 business case, that could last a significant amount of time, because you've got to get into the case. You've got to have what's called first day orders on financing and administration and retention of professionals. You've got to review all the leases and contracts and see what you're going to assume or reject. And then you need to propose and confirm a Chapter 11 plan. A small business bankruptcy, the subchapter 5 within Chapter 11, is going to be smaller. But again, we have no anecdotal evidence to tell us how long or how short those cases are going to last. So the costs associated with each, generally, and it's not a hard question, because fees are generally within what's called a safe harbor. So a Chapter 7 case should cost around $2,000 plus filing fees and associated costs like your pre and post debtor education. A Chapter 13 case should cost around, between $3,500 and $6,000. A Chapter 11 case is going to be expensive. Professional fees in a Chapter 11 case can run anywhere from $5,000 to $15,000 to $30,000, even higher, depending on the case, depending on the complexity. If it's a small mom and pop business, then I wouldn't estimate the fees to be more than $10,000 to $30,000. But a case like any of the department stores or really large national businesses, those fees could be in the millions of dollars. Again, it's all relative. And in a Chapter 7 case, fees are going to be due up front. In a Chapter 13 case, an attorney can accept some fees up front and then take other fees in the Chapter 13 plan. And in a Chapter 11, an attorney is going to get a retainer. He's not going to be able to draw on that retainer because all Chapter 11 fees are subject to court approval. So they'll get paid some pre-petition fees that they'll be able to draw on. Then there'll be an additional retainer that'll go into the Chapter 11 case, and then all fees will be paid over time during interim fee applications. There is no COVID relief. I don't understand the question, but there's no COVID relief from the government to assist with bankruptcy fees. The courts never advance any of those fees. Those are paid by the debtor. Yeah, unfortunately, you need some money to go bankrupt. And again, I'm happy to answer questions in a one-on-one setting via phone or Zoom, and you can go to my website and set up an appointment. Is there anything else? Going once. Not a problem. Going once, going twice. Thank you very much, everybody.
All right. Thank you, everybody, for joining us in our weekly webinar. Please join us next Tuesday at 12:30. We have our Grow with Google workshop. So you can go ahead and go onto the Chamber website and you can register just the way you did today. You'll receive a link to go ahead and log in again next Tuesday from 12:30 to 1:30. Thank you so much, Ron, for doing this for us. As always, your presentations they're really so helpful, and we love having you with us. And of course, again, just so everybody knows, This will all be uploaded to the Chamber's website under the webinar tab, as well as our Facebook and our YouTube page. So keep a lookout for that, or if you'd like to share it. And of course, we can go ahead and make sure that you guys get these individual slides if you wish to have them on file. So I'll give it another couple of seconds, and if you guys have any more questions, we can go ahead and answer them. But it doesn't look like we have any questions at this time. And we're very glad to have you, Bianca. We'd love to have you be a part of the Delray Chamber.
So as I said, feel free to contact me with any questions. Have a great day, everybody.
Thank you so much, everyone.